Hello, everybody. Welcome to webinar time. I am Chris Irons, Director of Strata Solve. That's stratasolve.com.au. Virtually alongside Frank Higginson, Partner, Hines Legal, Industry Expert of considerable renown. Frank, welcome.
Hello, Chris. Hello, everyone. That introduction to me gets longer every time. It's great. Can't wait to see what next week's one is.
Yeah, call it the cumulative effect, I suppose. Look, for those of you, if you're new to the show, first question, why? Second of all, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow us on Facebook, go to the Hines Legal page and hit the like button and icon. For YouTube, hit the subscribe button and the notification bell. Encourage your questions throughout. We'll try and get to those today, but if not, or if your question's a bit more involved, I suppose, a few more details, fill in the form that will come up on the link in the comments or in the chat function, and someone will get back to you. That's probably the easier option. We're going to talk about recording today, Frank, in this chat. Now, this question about recording at committee meetings, at body corporate meetings, Frank, it comes up all the time, doesn't it?
All the time. And I suppose I still get surprised to a degree when we get to these things. So why haven't we done that as a topic? I mean, we've been doing these for, well, more than 2 years now. I mean, for the arrival of COVID. And this is something that does come up a lot. We get lots of questions. There's, a bit of information online, but it's probably the stuff you see online isn't necessarily driven towards strata. It's always that interesting interplay, strata legislation, privacy, recording, criminal code, whatever it might be. How does that apply in a body corporate context? Because I think probably, and certainly, what you and I both see is people do want to have records of some of the emotional conversations they might otherwise be having in strata. People might be driven to record more so than in other places.
I think we're going to look into that why question in this discussion, Frank, a bit, because I think that's actually pretty important. Well, I think it's important anyway. I mean, whenever somebody sort of poses questions to me about recording of a strata meeting, my first thought is always why? Why are you doing it? What's the purpose? And I think that reveals a lot more about the situation than the actual recording. But we're going to talk about that anyway today. All right. Well, look, let's sort of kick it off, and let's start with the fundamental. Can you record? We should stress, Frank, we're talking about both audio and video recording here today. I think one and the same, really. Can you record? What does Strata legislation say about recording a meeting, Frank?
Nada. Not a single thing. So we have, I suppose, doesn't say you've got to record or you can record, doesn't say you can't record, it says not a single thing. So, we know now we can do electronic voting. We know that we can have meetings electronically, provided the committees decide to do so or the body corporate and general meeting has resolved to do so. And I suppose if anyone's ever sat in on a Zoom or a Teams call, or probably in fact almost any virtual technology, there's always the option to record those meetings. And normally when that happens, you get the little thing up on the top of the screen saying, hey, the meeting's been recorded. I suppose you got to click the button to dismiss, or it sits there the whole time, which acknowledges in a sense that you are aware that it's being recorded. But the strata legislation itself, complete and utter radio silence.
I don't know about you, Frank, but in clients that I deal with, I record quite a few meetings. Usually it's because the meetings are fairly long and there's a few things talked about in there and people want to go back. I always make a habit of saying, I'm just about to hit record now, everyone. Everyone's fine with that. And then I hit record. So it's two things. It's actually making sure, well, not making sure, but asking the question, which is more a courtesy thing than anything. And then it's, as you say, Frank, there's a notification. I reckon there's a lot to be said for that in a strata context too. What do you think?
Completely agree. And to be honest, I mean, we still do a lot of meetings on Teams, and, the typical lawyer advisor approach is to put things in writing, and writing is evidence of the advice you've given. So to the extent that it's not necessarily accurate or otherwise, there's the proof in the pudding. We don't necessarily do that for team meeting. I'm sitting here thinking, Chris, that's a good idea that we should be applying to the conversations we have with clients on Teams, because that's actually what's discussed. There's no arguments then about what the advice actually was, because people particularly can hear, and I suppose this is part of what recording anything's about. What I might say and what you might hear can be two completely different things, and probably more likely to be the case if we're diametrically opposed on a particular issue that we're talking about, and we're both emotionally invested in the outcome of a decision that's about to be made. So recording in that sense, I think is probably worth doing.
That's right. We should also point out that you talk about strata legislation not saying anything about it, nor does it talk about any kind of requirement to disclose. So there's nothing there about the recording, but there's also nothing there about disclosing one way or the other about the recording. So looking at that from both sides of the coin, nothing that says that an owner upon entering an AGM must disclose to all and sundry that they're about to hit record on whatever device they're using. Nor is there any requirement on the body corporate to do the same thing, interestingly enough. Which leads to some challenging questions, I think, Frank, on this one. So here's one for you. Would a motion prohibiting recording of a meeting, strata meeting, be a reasonable or valid motion, do we think?
I would probably say that motion's probably should be ruled out of order, completely off the cuff, without having ever given advice on this before. Only because motions are going to be ruled out of order if they're unreasonable, unlawful, or incapable of being given effect. So I would have thought that because the strata legislation is silent about recording, and there's other legislation that exists that actually allows it, trying to have a motion that prevents something that can be undertaken lawfully from taking place is going to be unlawful. That would be my gut feel.
I don't mind that logic.
Yeah.
I kind of come at it from the other perspective, which is that if the body corporate can resolve to conduct meetings electronically by ordinary resolution, they can also resolve to not conduct a meeting electronically. So similarly, here, could they not also resolve to not, in the same way that they could resolve to record a meeting, they could also resolve to not record a meeting?
Aha, okay. Probably a distinction there. I'd say in terms of the body corporate itself, possibly. In terms of what individual owners choose to do, probably not.
Yes. Okay.
So sorry, mate. The distinction there, and you can see, ladies and gentlemen, this is completely live and unscripted. It's an interesting thing because when we talk about recording, who's doing the recording?
Yep.
Is it the committee? Is it the body corporate manager? Is it the body corporate as a whole? Is it an individual lot owner sitting in the room? So, yeah, and I suppose by the same token, then, as much as best practice, you're talking about when you have your meetings. Okay, everyone, I'm going to record this now. Be ready. Blah blah blah. It's would a motion. This is, I suppose, I see your question. I raise you one back. Would a motion, let's say, put to a meeting by an owner that says that if anyone is going to record, motion for approval by ordinary resolution, that anyone recording the meeting be required to disclose that to everyone else before they press record?
Is that a motion that should be ruled out of order?
Yeah, or is that a valid motion? Certainly puts things on notice.
So you are changing, in effect, the rights of an owner? Would we say, could you argue that the rights of an owner are being potentially limited in that case?
Yes. Well, I suppose there's no obligation the rights or obligations. I don't think there's an obligation, which we'll get to, on people having to declare that they're recording conversations. So on what basis is a body corporate proposing to say to people, you must declare your intent before you do this, when you can lawfully do it without declaring your intent otherwise?
And I think ultimately it becomes unenforceable anyway, because if somebody disobeys that, how are you going to police it? So if somebody surreptitiously hits record at the start of the meeting and has not disclosed it, well, the only way you ever find out about that is through the recording afterwards. So it's not being enforced. So the motion would not be able to be enforced, would be my view on that one. But this is where the distinction between what is legislatively permissible and what's a courtesy or a best practice issue really kicks in for me. So to me, and we're going to talk about this a bit more later on, if you're going to record, why on earth would you not say so at the start? But to me, that's a no-brainer. Why wouldn't you say, well, I don't know, Frank. Why would you? Why wouldn't you?
Because I know you're going to defame me publicly, and I want you to do it, and I want to have it on record, and I want to come after you like Ben Roberts-Smith afterwards. Well, maybe not like Ben Roberts-Smith,
No,
but yeah,
like
it's an ambush.
Yeah,
Really,
okay.
that's one
All
way
right.
to do it. Is and maybe that's the typical negative lawyer in me. You go to the base reasons people do things that aren't necessarily disclosed, and it's to cause you some form of harm later.
So tactics.
Tactics.
All right, no, that's fair. I guess that's where, this is where the issue about why you are wanting to record the meeting becomes so important, I think, under the circumstances. That's an interesting one, that resolution. I wonder if that's actually been tested. I'm not familiar with it having been tested, one of those kinds of resolutions, where we might see if anybody can give us their own experience of that. Here's another bit curly question then, Frank. If a body corporate manager or a caretaking service contractor records the meeting, is that theirs or is that a body corporate record?
That is another interesting one. And I suppose the starting point is, what's the purpose of the recording, to my mind? So is it for their own personal purposes to recall what conversations were had, how the meeting went, or maybe even just to listen to it later on when they get the minutes to make sure that what was declared at the meeting in terms of votes for and against was accurate? You know, and I suppose because there's a parallel, like a body corporate manager and a caretaking service contractor aren't members of the body corporate in their own right. They, like a caretaker might own a lot, but that's in a different capacity potentially, as opposed to the corporate capacity that might have their management rights agreements. To me, probably a parallel is if you or I are at a meeting, usually if we're engaged by the body corporate to go, and we record the meeting, we're recording that for our own file purposes. It's not a body corporate record per se, and we're in a sense in the same contractual relationship with the body corporate manager or the caretaker with the body corporate, just under a different form of contract and for a different, probably one-off service. And I suppose interestingly then, you know, you talk jurisdiction, there's no reference to service contractors like you or I in legislation, really, is there? It's just that they're completely out of it.
So you can't, I mean, I think you're right, Frank. It probably is a body corporate record, particularly if the committee has instructed us to record it. I think that becomes pretty much a no-brainer at that point. But there's no compulsion upon us to hand that over. Certainly not within the jurisdiction of the Commissioner's office. There's zero. There'd be zero ability to do that. So that's another kind of pretty ambiguous issue. And I think what's emerging out of this discussion in the brief time we've been discussing about it is how out of step with practice Strata legislation is. And this is just one of many instances where the legislation is not at all contemporary with how things happen.
Behind the technology of the times, isn't it?
Yeah. And that may yet be something that has to be picked up in the review of the legislation, I reckon. How about another what if or a what about question then? So what happens if the recording gets deleted? Well, Frank, if it's gone, isn't it?
It is, mate. It's the same. I think probably this to me is parallel with written body corporate records. You can't produce what doesn't exist. So, and I think probably part of it for me then is, why was it deleted? Was it a mistake? Why did you drop your phone in the water and there was no backup to the cloud? Do you refuse to pay Apple for cloud backup storage and therefore you can't go and get it some other way? Or was it intentionally deleted because I did happen to say something defamatory about you and I've realised afterwards when I'm listening to the meeting, bloody hell, I'd better get rid of that, delete. So it's
delete does not always mean delete, does it? Just because you hit delete doesn't mean there is no record. How many times have we heard about somebody who scrubs their Twitter account? This always happens for candidates for Parliament, of course. Scrub their social media and shock horror, there's an archived version of it from years and years and years ago. Just because you hit delete doesn't mean it can't be found somewhere, which is all the more reason to exercise extreme caution about deciding to record in the first place, because the instant it happens, Frank, it's potentially there, isn't it?
It is. And once it's public, it's public. You can't put that genie back in the bottle, you know. And like my daughter's going through, she now grade 8, So they're all getting technology lessons at school, and they had a big scare the other day. Not that they brought in outside experts who had stalked some of the girls on what were their supposedly private snaps and things, Snapchats and things, and said, "You think it's private, but look what we found. Look what we found. Look what we found."
Yep.
So, yeah, unless you're a super rock star tech guru, the reality is if you put something in the public domain, you might never ever be able to put that back in.
And I think that's one thing to be very careful of. Probably the bigger thing to be very careful of is what you do with your recording. So there's the caution that you should take about creating the recording in the first place, and then it's about what you do with it, transmitting it, sharing it, broadcasting it, transcribing it, and publishing the transcription would be the other thing there. Which is a really nice segue to the next thing we're going to talk about. What always comes up here, Frank, is privacy considerations. So I'm not a privacy expert. You probably know a bit more about privacy legislation than me, I suspect.
I'll put myself in the same bucket as you, mate. No expert.
Well, for this, we went and consulted the government agency, which is in Queensland, the Office of the Information Commissioner. They have some really good resources there, actually, for people who've got questions, concerns about privacy. This is where to go. We'll put up a link to them shortly. Because they have been asked this question a lot about recording, they've actually put some content on their website about it. And they also make a reference to Strata, interestingly enough, on their website. So, but just be careful. It's guidance. It's not a direction or anything like that. But just, we're not going to read out the full thing because it's something for people to absorb at their leisure. But here's something that they say about audio and telephone recording. Generally, it is lawful to record a spoken conversation if the person recording the conversation is part of it and neither the consent nor knowledge of the other parties to the conversation is required. Okay, so that's that. Of course, there's a however, isn't there, Frank?
Always. There are laws applying to what you can do with recording and recording spoken conversations that you're not actually part of. So, again, start with, if Chris and I are having a chat over a coffee and I happen to put my phone down and it's recording our conversation, 100% fine based on that. I've seen people with little recorders in pens and all sorts of things. So, but if you're not part of the conversation, so I suppose if we have someone sitting beside us on an adjoining table and is recording the conversation and they're not part of it, that is going to be a breach of the law.
Yeah. There's a lot more of that information on that website. We urge people who've got questions about it to go there because we're not in the business of answering privacy related questions. We're in the business of looking at it from the Strata perspective, but absolutely go and check out that information and contact them. Contact the Office of the Information Commissioner in that case. As I say, we'll put up the link to that one. All right, which leads to the next question, I suppose then. Frank, do you have to inform anybody if you're recording?
No. No. If you're party to that conversation, so again, I suppose if we've got old mate sitting on the table beside us trying to record us, then that's illegal. But if I'm recording a conversation with Chris, no problem at all. Go for your life based on this. And I suppose then, and this is what the Invasion of Privacy Act then deals with. And it's interesting, from I suppose 1971 was when this was created. Clearly, maybe we were back to the days of Get Smart and shoe phones were just starting to appear on the horizon. I don't know. As this legislation's clearly been updated, and it does allow conversations that have been recorded to be passed on, but only in very sort of specific circumstances. So one of them, the example they give, is to another person who was part of the conversation. So again, Chris and my coffee shop conversation. Chris, just to let you know, here's a recording of what we chatted about. No problem at all. But then what it does say, and again, this is all on the website, but just smashing through it a little bit quickly for everyone's benefit, you're not allowed to distribute it more than is reasonably necessary in the public interest. And so again, Chris and my coffee conversation, if it's talking about what the webinar topics are going to be for the next 3 weeks, I'd probably suggest that it's not in the public interest for anyone to have that information. I would
struggle to think of anything that happens in Strata that would be in the public interest, Frank. I would really, the only thing I could potentially think of would be if there is some kind of alleged criminal activity happening at that strata scheme. Yep.
If we're both ministers of the government, we're talking about bribing someone to produce a certain outcome, I'd say that is in the public interest. That's well and truly on the other side of the coin. But other than that, it's sort of a personal conversation. It's pretty hard to think. You got the right to forward on. Obviously, in the course of legal proceedings, if you get subpoenaed with evidence, I want to hear the recording of that coffee conversation, then bang, all over. And probably they're the main ones, really. So I think probably what both of us would be saying to people that are interested in recording things and then potentially sharing them, it is something definitely to get legal advice on. Yeah. This webinar is not that legal advice. This is definitely not that. It's got to be very specific to the circumstances.
Yeah, I think we're here today in the business, Frank, of trying to give people a few pauses for thought, if you like, because I think this is more directed at people who have the interest in recording a Strata meeting and trying to give a bit of form around that. So come back to a point that I said right at the start, which is, well, what are your motives for recording? So I think, to me, there are some certain situations for which your motives for recording make perfect sense. So your memory isn't great.
Yeah, English might be your second language and the meeting's being conducted in English and you want to go back to what actually happened.
Yep. Hearing not great. Works for me. Not familiar with technology. So say, for example, there was a really involved technical issue being discussed at a GM, which happens, doesn't it, Frank? Like a contractor talking about, I'm trying to think of a good example, thermodynamic imaging at the scheme.
Fire panels, yeah.
Yeah, well, I don't know, what's that? And it all passes by you at the meeting, and then you're like, I really wish I had some way of remembering what that discussion about thermodynamics was. Okay, that works, I reckon. A presentation by guest speakers, that kind of might be a reasonable circumstance for wanting to record. But this is where you and I might differ just a tad, Frank, but here's what I think are not great motives for recording a meeting. Revenge, spite, exposure, entrapment, intent to plaster over social media, paranoia based on misunderstanding or personal interactions, or a gotcha that you hope to have on a current affair later that week. I don't know. What do you think, Frank?
Yeah, no, absolutely. But that probably is the reason most people would record. Yeah. That's the difficulty. And I suppose one of the benefits of, recording from a body corporate sense, and I've actually have suggested this to clients in the past when they've got meetings that are particularly contested, is to declare it up front. So this is before we were doing all online meetings. Is everyone, we're recording the meeting because there's a whole lot of heated conversation going on at the moment. So we've got an accurate record of what goes on. That tends to slow people down in terms of accusations, defamatory statements, abuse, all that sort of stuff.
I think that's a really good point, actually, Frank. So it's this question, I suppose, about what you do at the start. How should you do it? Your comment, Frank, about tactics is a very well-made point, and I concede that point, absolutely. That point you just made then is a very well-made point, and I concede that one too. I think if you can, my personal view, if you can be honest about it, you might as well be. I think in this scenario.
I agree. Transparency is a much better place to be if it's at all possible. And it usually will lead to a better outcome.
I agree. So are there alternatives? Well, of course. If you're from the committee's point of view, I think you agree, Frank, that if you have owners who are wanting to record meetings and it happens all the time, and particularly if you find out it's happening surreptitiously, I think as a committee you need to be asking yourself why, and is there a systemic issue there? What do you think, Frank?
Yeah, and it's probably this is. I mean, there's two sides to this coin, definitely. And from a committee perspective, it is you're looking over your shoulder about what's coming next. And from the owner's perspective, they're recording it could be because they're barking completely up the wrong tree in relation to whatever the issues are the committee's discussing. So, with that one, from a committee perspective, you've got no choice but to be transparent and accountable. People can come to meetings, people can hear the conversation, provided they don't have an interest in it. So I think probably the best thing for a committee to do if they know that's happening for me would be A, have a conversation with the people as much as you probably know what the issue is that they're actually concerned about, and B, go in with some of the right coaching in terms of form, structure, conversation, dot points to hit, how to run the meeting in a way that would be above criticism at a later stage.
That's it, above criticism, Frank. From the owner's point of view, then I don't know that you need to recall 100% of every single word, utterance and phrase at the meeting. I'm not really sure if that's necessary, unless, of course, you're wanting to sue someone for defamation, which I think this is the wrong webinar for you, if that's the case. Yeah, look, think about whether you need it for all of those reasons or not, and whether there's actually something else you can do to, if the situation is based upon some contention or sensitive issue and that's motivating your recording, perhaps approach it from that angle instead. If it's based upon a personal piece of animosity or dispute, perhaps look at resolving the situation through some alternative dispute resolution means or some other means, rather than focusing on the recording as the treatment for the issue, I guess is what we'd say. Yeah.
And dare I say, Chris, I'll just throw this out there. If you're a observer at a committee meeting, are you part of the conversation being had?
What if you don't say anything?
Yeah, well, and when you're an observer at a committee meeting, you're not entitled to.
Yeah. I've certainly been at meetings on behalf of clients where I've not said a thing. Yeah, I don't know. I think there's enough ambiguity here to, again, emphasize the point that you just got to be so careful. If we can't answer the questions conclusively, neither can you, I suspect, which is why you need to exercise caution. And of course, the final point to make here, Frank, what's wrong with good old-fashioned minutes?
Nothing. And you talk about what a committee's role is. It's to make decisions. So you'd think that the extent of trying to record a committee conversation is a little bit academic in a sense, because it's just a discussion around whatever a particular issue might be. It's probably not going to be defamatory per se. It might be you saying we should go with the off-white and me saying we should go with the beige, and we compromise on the cream, and that's the thing that goes up. You know what I mean? So, like, in a sense, who cares?
Yep. If the meetings are if the minutes are problematic, focus on that rather than the recording being the solution.
Or the decisions themselves, isn't it?
Yeah.
That's an unreasonable decision. How they got there is for them to later justify, but I don't necessarily think recording the conversation is a substantial part of that.
No, it doesn't advance things. I wouldn't have thought too much. No. All right. We've reached the end. That's it. I dare say there's going to be a fair bit of follow-up to that one.
Yes.
Just a really quick reminder, everybody, if you are new to the show, we live stream to YouTube and Facebook every Thursday at 2:00 Brisbane time. So to follow us on Facebook, go to the Heinz Legal page and hit the like button and icon. For YouTube, hit the subscribe button and the notification bell. We will have some show notes after